Thank you, Your Honor. For the record, my call on behalf of the people.
And good morning, Your Honor. Attorney Cooper Dobies, P number 87722 on behalf of Ms. Steele. Ms. Steele, could you state your full name for the record?
Leah Marie Steele.
Thank you. This is the date and time set for sentencing in this matter. Mr. Dobies, I did receive your sentencing memorandum. I had a chance to review that prior to the hearing today. Ms. Steele, have you had an adequate opportunity to go through the pre-sentence report with your attorney?
Yes, Your Honor.
Mr. Dobies, are there any additions, deletions, or corrections to the factual information within the report?
Yes, Your Honor. There were just a couple. I'm going to start on CFJ 145, page 2 of CFJ 145.
Okay.
On the what I'll call the sentence that's a recommendation that discusses what the sentencing recommendation is. I believe there's an extra period in the middle of that sentence at the end of the first line. At least it looked like it was like that on my copy. So I think that was just a typographical error.
Where is that?
Where it actually talks about, one moment, Your Honor. So it's going to be, it is respectfully recommended that the defendant be sentenced to incarceration at CO County Jail with credit for 11 days served. It looks like on my copy, right after the word served, there might be a period there.
Yep. I see where you're talking. Okay, we'll make that correction.
And then CFJ 284, page 4, where it discusses Ms. Steele's family, her half-brother, that should be Steele on the last name. I believe that is just a typographical error as well.
Stell, yeah, okay, we'll make that correction.
And then just one addition on CFJ 284, page 6, under the substance abuse treatment section. Ms. Steele does have a bed waiting and ready for her as of tomorrow at the Sacred Heart Clearview Women's Rehabilitation Facility in Richmond, Michigan. So I would concede that she has not started that yet, but I suppose it would be appropriate to maybe list tomorrow as the start date because she does have a bed ready to go. And that would be an inpatient treatment.
Mr. Rolla, do you have any objection to adding that information in?
No, Judge.
Okay, we'll add that in then under that section. Any other?
That was it for me, Your Honor.
All right, and Mr. Dobies, are there any challenges to the scoring of the guidelines?
There are not on either count, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections, Judge.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Yes, thank you. As to the request for 7411 in this particular matter, there is no doubt in people's mind that the co-defendant, Mr. Pearl, who, by the way, was the gentleman who logged in and told the court that, oops, I'm sorry, I dialed the wrong number.
Okay.
For the court's information. I noticed the court officer also recognized that, and he can confirm that for the record should the court need it. But there's no question that Mr. Pearl, who's also the father of the party's child, bio-father, I use that term as bio-father because I don't know that it's the full definition of father, used Ms. Steele effectively as a drug mule to shield himself. I would point out to the court that even though that's the case, as the court's well aware that this defendant already received the benefit of having counts 1 and 2, which were 20-year Class B felonies, and counts 5 and 6 also dismissed. That would have resulted in a recommended mandatory prison sentence. Further, this is a situation we were talking about over 12 grams of methamphetamine, actually almost 50 grams if you add in the 30 additional grams that the third party, Mr. Larry Monk, had. If the court recalls at the car wash, that's where they had 30 grams were stashed. If the court remembers in this particular case. Also, this case involved Xanax, which is alprazolam, hydrocodone, as well as clonazepam. As to additional reasons why this should not, and quite frankly, I don't believe cannot go as a 7411, it would create sentencing problems in regards to reporting it, because the offense for it involves a weapons offense, and that has to remain a public record up until or unless at a later date in time the defendant was in a position to appropriately bring a motion to set aside a prior conviction. That's different from 7411, as the court's well aware. So I believe there are both legal, factual, and practical reasons why 7411 should not be ordered in this particular case. As to the rest of the recommendation, I think it's appropriate with, of course, the fact that the metallic buckles are confiscated and condemned pursuant to MCL 75239. Thank you, Judge.
Thank you, Mr. Dobies. Anything on behalf of your client today? And again, I did read through the sentencing memorandum, so I'm kind of aware of your position on the case generally and the 7411 request.
Thank you, Your Honor. I'm going to strive to not repeat too much of myself from the sentencing memorandum with that understanding. Ms. Steele comes before the court, as I believe Mr. Rolla outlined, in a pretty precarious position. I think that's fair to say. And getting involved with an individual that's very well known to this community. Obviously, Ms. Steele did not know that at the time. She's come to be aware of that. But I think that this court should know that Ms. Steele has taken her sobriety very seriously. As the PSI indicates, Ms. Steele has not been involved with methamphetamine for that long. I say that not to minimize the fact that the scourge that methamphetamine is on this community in this state, but I say that to just observe to the court that Ms. Steele has not, she's not too far gone in terms of her ability to be rehabilitated and recover from this substance use addiction. And as I mentioned before, allocution, Ms. Steele has now taken it upon herself to engage in inpatient services. During the pendency of this case, she has taken advantage of outpatient services. Quite frankly, she believes she needs a little bit more structure than that in order to overcome the substance use disorder. So that's why she's taken it upon herself to, again, this inpatient treatment. I understand how this case started out. It started out as a delivery of methamphetamine case. So I'm certainly not blind to that. And in regards to the sentencing recommendation, the probation and parole department has recommended a term of incarceration consistent with the guidelines, but a jail-only recommendation. I certainly understand the punishment factor that this court has to take into consideration. I would just ask that if Your Honor is inclined to give any jail, I would be, first of all, asking for no further jail as I outlined in my sentencing memorandum. But if Your Honor is inclined to impose additional jail beyond the 11 days that Ms. Steele has served, I would ask that that be held in abeyance pending this inpatient treatment that Ms. Steele has verified to me that she has a bed for. And if she successfully completes that inpatient treatment, I would ask that she be, to the extent that the court is willing to do so, give her day-for-day jail credit, as long as she successfully completes that inpatient programming. And I will leave it at that, Your Honor, as to not repeat myself too much. Thank you.
All right, thank you. Ms. Steele, anything you wanted to say today? Okay. As you've heard, I did read through all the reports that were filed in this case, so I'm familiar with you, generally your background based on the information in that report, your past history, and what happened in this case. Obviously, Mr. Dobies' memorandum went into a little bit more detail and provided the court with some additional information just about your general circumstances. And there's a couple of aspects of this case that I think stand out. Number one, it appears that you were involved pretty heavily in this delivery circumstance, and probably others as well, due to your association with these other individuals. And if you don't know it already, you're going to find that the more that you associate with people who are involved in this, the more you're going to get dragged into it yourself. Whether you start out that way or not, you're going to end up involved in it. And that's why you're here today. And I generally look at cases involving delivery with a much more critical eye than I do just use or possession cases, because not only are you using, but you're bringing it here and making it available for other people to use. And that presents a danger to our community. And those things are all what I would consider aggravating factors, or make a case for you doing some jail time much stronger than it would otherwise be. I also think there's some mitigating factors here. Number one, your lack of any real past criminal history, I think is significant. I think that gives the court some reason to believe that it should look at rehabilitation first, rather than punishment. And while it does appear to me, based on the report, that you've had some slip ups while you've been on bond, I also am seeing evidence of some sincere efforts on your part to get help and get treatment. And one thing that I tell people all the time is it's one thing for the court to order somebody to do it, or for somebody to do it because they want to keep themselves, make it look better. If you're seeking treatment on your own because you want to get better, that's when it's really going to be effective. And so I hope that's the reason why you sought this. But either way, again, it gives me some reason to believe that there's potential for rehabilitation here. So when I look at all of those factors and trying to come up with a sentence that I think is fair and reasonable and addresses your conduct, but also the rehabilitation aspect, in my view, and in particular, given your lack of any past history, that probation is appropriate for a period of time to provide for supervision and oversight. I think jail time held in abeyance so that you understand that if you don't comply with probation and treatment, which I'm going to discuss here in a second, that there's a significant jail sentence waiting for you on the other side of that. And if I give you the opportunity for rehabilitation up front and you don't take that, or you don't follow through with it, if you're back here, you're not going to have any argument really that's going to convince me that you shouldn't just go to jail, because you will have had that opportunity and you will have rejected that opportunity. So I'm going to place you on probation for a period of 24 months. That's definitely not the easy way out. That means you've got 2 years that you're going to have to toe the line. I'm going to impose 12 months in the Otsego County Jail with credit for 11 days served. I will allow you to be released to treatment immediately. And if you successfully complete that treatment, then the court will give you day-for-day credit for the time that you're in the inpatient treatment at Sacred Heart, I think, is that what you said?
Yes, Your Honor.
And then if you successfully complete that program and you're released, then I'll continue to hold the remaining jail time in abeyance. Now, you'll still be on probation after that. And if you violate your probation, I can impose that jail time. So it doesn't just go away by successfully completing your treatment. But hopefully that treatment program is going to give you the tools you need to stay clear of this during the time you're on probation. If you don't successfully complete the probation or you leave, if you don't successfully complete the treatment or you leave before the program is finished, you're going to have to report to jail. If you don't report to jail, we'll issue a bench warrant and you'll be arrested and brought to jail. And I want to confirm that you do have a bed available. So you're going to be taken into custody here today. Mr. Dobies, you can work with the jail as long as they have confirmation from Sacred Heart that she's got a bed available, then she can be released tomorrow to go to the treatment. In terms of the probationary provisions, the court is going to adopt all standard terms and conditions of probation. You need anything more than that, Mr. DeLeo? Okay. And again, that would be for a period of 24 months. The court is going to order a crime victims assessment of $130, court costs of $325, a DNA testing fee of $60, and a $68 state cost, along with a supervision fee of $30 per month while you're on probation. And Mr. Dobies, if you could have Ms. Steele acknowledge receipt for appellate rights there.
Which condemning the teleconference, Your Honor.
Yes, for the record, the court will order that those be seized.
And Your Honor, just for the record, I'm going to place on the record that my client is right now dating and initialing the appellate rights stuff.
And if I didn't say it, Ms. Steele has 11 days credit.
That's correct, Your Honor, yes.
Leah Steele stood in court for sentencing on serious drug charges involving methamphetamine. Prosecutors argued she was used as a drug mule in a dangerous operation, while the defense emphasized her lack of criminal history and commitment to sobriety. The judge acknowledged the severity of the case, but also recognized her efforts to seek treatment on her own. Balancing punishment and rehabilitation, the court chose probation instead of immediate incarceration.
And Mr. Dobies, just so you're aware, I've got this worksheet that I'm providing to the jail that indicates that Ms. Steele can be immediately released to treatment upon confirmation of bed at Sacred Heart. So
Thank you, Your Honor.
that to you. And good luck to you going forward.
Thank you so much.
Thank you, Your Honor.
Yes. Mr. Brown, did you have Miss Haley
Mr. Haley?
or Mr. Haley? Yeah, sorry.
is lodged downstairs, Your Honor.
Oh, okay. Yeah.
And Judge, that was not with 7411, correct?
What's that?
That was not with 74. Okay, thank you.
Are both of your clients lodged, Mr. Brown?
Who's the other one?
Ms. Hammond?
We could call that case.
We'll call People versus Kimberly Hammond. This is file number 256869. If I could have counsel.
For the record, Your Honor, my call, yeah. There's Brown, we got it.
This was set for hearing at 9:45. It's now 9:55. Have you had contact with Ms. Hammond today?
I have not, Your Honor. I did send an email to your assistant as well as the prosecutor that the phone has been disconnected. I have not had any response to my emails. I did reach out to Jessica Van Wolfen to see if she has been reporting. We do have the same phone number, and Ms. Van Wolfen has not had contact with her since October. That is when we had, I believe, a motion hearing.
Okay. All right, we currently have that set for trial on January 30th. Sir, is your name Michael Haley?
Asked if you were Haley.
Yes, sir.
Okay. We'll go on the record in People versus Haley. This is file number 256876. The record should reflect Mr. Haley's present today by video from the Otsego County Jail. If I could have counsel put your appearances on.
Thank you, Your Honor, for the record, my call, people.
Larry Brown on behalf of Mr. Haley.
All right, Mr. Brown, this is set for a motion to withdraw.
It is.
Are you
Your Honor.
appointed in this case?
I was appointed in this case. This is at my client's request. He did submit a request to Mr. Slough as well, which I don't know if the court received that, but I was notified on the 16th, which I believe was Friday, that request has been denied. Mr. Haley has advised me that he may be looking, I guess he could expound on this, trying to retain Mr. Jeffrey Weiger as his private counsel. At this point, in my meetings with him, we have gone over this case. We've reviewed video footage, different things like that. I'm a little, unless he definitely just wants to retain private counsel, confused because we seem to agree on pretty much everything as far as the facts of the case, the strategy, the trial going forward. I've explained to him some of my strategies.
The judge sentenced Steele to 24 months of probation and imposed a 12-month jail sentence, but held it in abeyance. She was ordered directly into inpatient rehab, where every successful day counts as jail credit. The warning was clear: complete treatment and follow probation, or the jail time becomes real. One opportunity, strict conditions, and no second chances.
Are you having trouble hearing, Mr. Haley?
Yes, Your Honor. He's turning up the volume.
Okay. All right, go ahead, Mr. Brown. Maybe if you can just speak up a little bit too, because the microphone's over here.
I can hear fine now.
Okay.
There are some things that he wanted me to do, which I did go over those with him. I don't want to get into our conversations, but he seemed to understand certain reasons why I might not want to do those, that it might actually hinder the case. There was some witnesses that he wanted me to contact that he thought would be very helpful. Two of them I am trying to track down, but all I have is a name. I don't have an address or a phone number. I did contact one and did explain to Mr. Haley, I would not call that person. I believe it would be extremely detrimental to his case. So I'm at a little bit of a loss. I did file the motion to withdraw because that is what he wanted me to do, and he is trying to get new counsel. But at least the way I see the case and in my conversations with him, I think we both agree on the way it's headed forward, and I was going to go down and go over some things that we are going to need to do if this trial proceeds on Monday. But if he can retain new counsel, I would definitely not want to infringe upon his right to do that.
All right, Mr. Haley, we have your case set for trial starting next Monday. I'm not going to appoint a new counsel for you. We've went through that process. I don't think there's grounds based on what Mr. Brown has stated today. So your only other option would be to hire a different lawyer for yourself. If you did that, I'm sure that that lawyer would want to have some time to prepare for your case. And that means that we'd have to adjourn that trial, and you are going to spend more time sitting in jail waiting for a trial date. So how do you want to proceed with your case?
Well, as Mr. Brown said, we have not had a good working relationship. He makes promises he doesn't follow through with. I made a request quite some time ago to change the attorney to avoid this eventuality.
Yeah, and I understand that, and that request was addressed, and it was determined that whatever, differences you have, they aren't significant enough that it would warrant having a new counsel appointed.
I was completely unaware of that, Your Honor. I thought I had no idea that it had been denied.
Well, that's where we're at.
Understood.
So again, I mean, your options at this point are to proceed with trial with Mr. Brown next Monday. Or you can try to hire your own counsel. And again, I'm sure that any attorney coming into the case now is not going to want to have to try and go forward with the trial, especially given the nature of the charges here, without any time to prepare.
Understood, Your Honor, but I do not have funds to hire another attorney.
Okay, so I'm going to proceed with going forward with the trial next Monday then. And I encourage you to communicate as much as you can with Mr. Brown between now and then and address whatever differences that the two of you have. But we need to go forward with the trial.
Understood, Your Honor.
Okay.
All right, Mr. Brown, anything further?
No, Your Honor, and I will be contacting his son, and if I can't get anywhere there, I am going to ensure that he has clothes for trial.
Okay.
I don't think he brought any. Mr. Haley, you didn't bring clothes into the jail, did you?
Only what I had on. And
Okay.
I asked, and those aren't even here for some reason.
Okay, so Mr. Brown, again, yeah, I'll just ask that you take whatever steps necessary to make sure that you're ready to proceed with Mr. Haley's case next Monday, and that Mr. Haley has street clothes. I believe we've already had jury instructions submitted.
We did them a while.
So Mr. Brown, if you could just submit any review the prosecutor's instructions, if there are any that are different or ones that you need to add, if you can just submit those.
Yes, Your Honor.
To the court. I believe, Mr. Rolla, how many are you still anticipating? I think we had set for 4 days, is that correct?
Yeah, Judge, and with the number of witnesses, the number of lab personnel, I think it's going to take all of 4 days.
Okay.
Yes,
All right.
4 days.
Mr. Roll, anything further for the record today?
Not in this case, thank you, Your Honor.
All right, Mr. Haley, do you have any other questions today?
No, Your Honor.
Okay, all right, thank you. That's all for this hearing. The court is going to disconnect at this time.